Hello, folks. Good afternoon or good morning, depending on where you are. My name is Dara Lind. I'm a senior fellow at the American Immigration Council. I'm moderating today's webinar on to El Salvador and beyond, third country removals, due process, and Trump's assault on rights. I'm joined here by two of my colleagues at the council, Nena Gupta, our policy director, and senior fellow Aaron Reichlin-Melnick, as well as two expert guest speakers, Will Freeman of the Council on Foreign Relations, who's a Latin America fellow there, and Simon Sandoval Moshenberg, who's a partner at Murray Osorio PLLC, and who is the lead attorney for Mr. Kilmar Abrego Garcia, whose name you may recognize. He's the Maryland father who was deported to El Salvador in what the government admits is a mistake. We will obviously get into more of the details of his case later on in today's webinar. Per usual, if you've been on a council webinar before, the way that this works is that questions can be asked using the Q&A button at the bottom of your Zoom screen. Some of those we have folks who are going to be going through and answering in writing. Some we will have answered during the Q&A that's going to come after all of the speakers have given their presentations. We cannot do anything that is construed as legal advice, and we are not speaking to individual cases where we don't have someone who is directly representing the client. So if you can just bear with us a little bit, there may be questions that we refrain from answering because we're worried it's going to be on the wrong side of that line. After today's webinar, you will receive an email with the recording as well as with other resources that might be helpful for you as you continue to learn more and engage on this issue. I'm going to turn it over to our expert speakers who know way more than I do in a second. But first, I think it's important, just because there have been so many developments in this over the last 4 weeks, to just give us the kind of overview of what's happened in the state of play. On March 15th, the Trump administration published an invocation of the Alien Enemies Act, an 18th century law that the Trump administration alleged gave them the power to deport whole classes of people with no due process whatsoever, based on an allegation that they were engaged in an invasion against the United States. Specifically, that proclamation applied to Venezuelan men 14 years of age or older who, according to the government, were members of the Venezuelan gang Tren de Aragua. Almost immediately after that proclamation was published, the flights left for El Salvador with people who were being transferred under the Alien Enemies Act, including 137 Venezuelan men, as well as others, including 101 Venezuelan men who were being removed subject to having final orders under the Immigration and Nationality Act, approximately 23 Salvadoran men, and several Venezuelan women and one Nicaraguan man who were ultimately returned. To be clear, all of these numbers are based on reporting. They're not based on anything the government has officially provided. So all of those should be construed as approximate. Some of these folks, the folks who had final orders under the Immigration and Nationality Act had received removal orders from immigration judges. However, those who had never seen a judge or had a day in court, had absolutely no opportunity to protest that they were eligible for relief under U.S. immigration law, or to challenge the supposed allegation that they were members of this Venezuelan gang that had not been proffered in a formal proceeding and just named as the reason collectively. Not only were they being removed, but they were being removed to El Salvador, where President Nayib Bukele had agreed to house them at the fairly notorious prison called Zicot, which has been used for alleged Salvadoran gang members, and where there were immediately propaganda videos posted by the Bukele administration showing the humiliation of these men. Before the planes had even landed, a U.S. federal judge had issued an order temporarily barring the federal government from deporting anyone under the proclamation, while a suit brought by the ACLU and Democracy Forward on behalf of several Venezuelan detainees moved forward to determine whether Trump's use of the Alien Enemies Act was legal. But despite a verbal order from that judge to turn the planes around, the two planes landed in El Salvador and were unloaded, with Bukele mocking the judge on social media and American officials retweeting the mockery. Fast forward to this week. Obviously, there's been plenty of legal back and forth in the intervening time, but what you need to know is that as of right now, as of a Monday night ruling from the Supreme Court, the that judge's order has been overturned. We're going to talk more about what the SCOTUS ruling means in practice, but what you should know for now is, one, all 9 Supreme Court justices agreed that a person must be given notice and reasonable time to contest any allegation that the government is making to deport them under the Alien Enemies Act. 2, by a 5-4 majority, the justices said that the appropriate and only procedure to use to challenge a deportation under the Alien Enemies Act was to file a habeas claim, which is short for habeas corpus, the ancient right not to be held without knowing why, in federal court, wherever the person is being detained prior to their removal. So because the March court order was not issued by the right judge on the right grounds, according to the Supreme Court, it was essentially nullified. Monday's ruling didn't say anything about what relief could be available to the 200 plus people who are already in El Salvador, despite agreeing that the way they'd been sent there violated the law. We'll talk a little bit more shortly about what else it didn't say. Of course, in the weeks since those flights landed, the public has benefited from some really excellent reporting, some really courageous representation from lawyers, including, Simon and his peers, that have helped us understand who these people were. So you may have heard the case of Andres Hernandez Romero, the gay makeup artist who came to the US fleeing homophobic persecution and who ended up missing a hearing in immigration court where his lawyer was ready to make a case that he was not at all affiliated with the gang, but instead was told that he had already been sent to El Salvador. You may have heard the case of Jose Reyes Barrios, who was apparently sent to El Salvador based on a tattoo he had honoring Real Madrid because he'd been a soccer player in Venezuela. Or the father of a 1-year-old, Frangel Reyes, who was detained from Florida and sent to El Salvador based on files that called him an affiliate of Tren de Aragua while getting his name and gender wrong. Of course, in one case, the Salvadoran father living in Maryland, Kilmar Abrego Garcia, the government acknowledges that he was wrongfully sent there because there was an explicit order preventing him from being sent to El Salvador in particular, which Mr. Abrego Garcia's lawyer will offer more detail about when we have Simon talk more. So what we know is that while ICE insists there was some kind of rigorous process, it will not divulge any details, and an internal validation guide that the ACLU has provided in its filings demonstrates that you could be qualified as a member of Tren de Aragua based on meeting an 8-point minimum on a 40-point scale with tattoos, social media posts, and endorsements from other unspecified government agencies, all being things that could help get you to that 8 points. Now, understanding the kind of facts of this, we should get it more into the legal background and what due process is supposed to mean in court, what it usually means in the immigration context, and what it means here. And Nana, I'd like you to kind of talk us through that, because obviously folks like you and I have said for ages that there isn't due process in the way people usually think about it in immigration. So what's the difference between what usually exists and what we're seeing now?
Thanks, Dara, for laying out a lot of facts. And hi, everyone. Again, I'm Naina Gupta. I'm the policy director here at the council. Thanks for joining us. I know there are a lot of questions coming in the Q&A already, and we'll do our best with those. So, just to start, as Dara mentioned, there were approximately 130 folks, at least, who were sent to El Salvador, to this notorious prison, who had no final orders of removal. No final order of removal means there was no hearing in which an immigration judge made an ultimate decision that a person was in fact subject to be deported. This means there was no chance, no opportunity to refute what are seemingly sham or flimsy gang allegations. The government did not have to prove its case in any kind of court of law with any kind of adjudicator. In many ways, the invocation of the Alien Enemies Act has been a mechanism to get around the typical due process requirements under the Immigration and Nationality Act. And so just as a step back here, it's important to consider in a regular removal proceeding, what does due process offer non-citizens under the INA? And what is the government allowed and required to do when it does allege that someone has ties to a criminal organization or a criminal record with certain convictions? So First, as many of you know, the government can remove somebody based on a broad range, or rather put somebody into removal proceedings based on a broad range of criminal convictions. The criminal grounds of removability under immigration law include many prior offenses. They use legal terms of art that encompass things as small as shoplifting or larceny, and even include convictions that are decades old. There is no statute of limitations. The government can also already, under existing immigration law, deny people relief from deportation based on criminal convictions or even allegations of gang involvement, either in immigration court or in applications that go before USCIS. And when this happens, particularly in an immigration court, the government does have to show some proof of a person's conviction, some record that this is a prior offense, and at least some evidence of gang membership, although there is a history of flimsy and weak evidence being proffered for gang allegations in the US immigration system. Now, what due process then exists for a person facing deportation in a typical immigration case? How can they respond? The first thing to know is that in regular immigration proceedings, right, non-citizens do not have the same due process rights that people in a criminal proceeding where they're facing similar punitive consequences like detention or deprivations of liberty have. So in the immigration system, there is no right to an appointed lawyer. Over 60% of people are navigating removal proceedings without a lawyer in the first place. There's also no opportunity to confront somebody making certain accusations. So in a criminal case, a police officer who writes a report saying, I saw this person hanging out with gang members, that accusation, if made against a defendant, that defendant has the right to call that police officer and cross-examine that information. That Sixth Amendment confrontation right does not exist in immigration proceedings. Neither do the federal rules of evidence, which set some guardrails on what kind of evidence is reliable and allowed. And there are even relaxed Fourth Amendment protections that allow evidence obtained in violation of certain constitutional rights to still be entered into the immigration court proceeding. So we're already in a system where there is an abrogation of these basic constitutional rights. But even then, in a usual removal proceeding, a non-citizen does have an opportunity to refute allegations. They can testify before an immigration judge as to who they are and why these allegations may or may not be true. They can bring in family members, employers, witnesses who speak to their character and background and past. They can bring in experts, much like the experts we're hearing from now in the public record, who have underscored that tattoos, in fact, are not a marker of membership in the Venezuelan gang Tren de Aragua. Those are experts who would testify in individual cases like this to refute the idea that some of these tattoos, in fact, have anything to do with gang membership. And so what is happening here with these removals so far under the Alien Enemies Act is well beyond the bounds of the already low level of due process in the immigration system. And there are a few implications to consider in this sidestepping of these processes. So, for as many advocates and organizations have pointed out, this is essentially disappearing people. Alleging people to have some sort of connection and then immediately putting them on a plane to a foreign prison. This, many have offered, meets the definition of a rendition under international law, a government kidnapping or capturing of a person and sending them to countries that use torture or abuse. And we'll hear in a few minutes more about the conditions in this particular prison. It also, of course, sets a precedent of the administration violating basic notions of a fair day in court and imposing punitive consequences with literally no ability to challenge. And then finally, when there's no due process, there are obvious mistakes and sham or false allegations that can easily be used. This gives state actors the authority to weaponize laws. We're seeing the stories and experiences that underscore the effect of no due process. The makeup artist on 60 Minutes this past weekend, the fact that we have experts saying, wait a minute, these can't be folks associated with Trinidad if all you have is evidence of tattoos. That is actually information that would have been considered in a proceeding with due process. And finally, we'll hear in a moment from the lawyer for Mr. Kilmar Abrego Garcia, who's been deported when the government had been explicitly ordered not to do so with regards to a removal to El Salvador, which again is a mistake that occurs when you don't have a meaningful set of processes in place. And finally, before I turn this over to Simon, I did want to add a few points on the Supreme Court decision that we saw this week and what it means for due process going forward. So, as Dara pointed out, the justices on the Supreme Court agreed that there must be some form of due process before somebody is removed under the Alien Enemies Act. The court did not rule, just to be clear, on whether it's appropriate to invoke the Alien Enemies Act, but they did say if you're going to challenge that invocation, you have to do it via a habeas petition. And they specifically added that there must be notice and a reasonable time for a person to respond to this impending removal. Now, in principle, this of course supports the due process, like I just described. But in practice, there are some significant barriers regarding how we expect this to play out. In a system where there is no right to an appointed lawyer, getting a lawyer to file a habeas petition will be incredibly challenging, especially for people who are sitting in detention. We know that filing habeas petitions pro se is incredibly difficult, especially when we're talking about many people who don't speak English. Habeas petitions, second of all, can take months to litigate. In that time, people will be subject to detention in a system that has a documented record of abuses and inhumane treatment that are endemic to the system. They will have to wait in those conditions while their cases are being litigated. The third is that this will lead to likely forum shopping, something pointed out in one of the dissents in the Supreme Court decision. Since habeas petitions have to be filed in the venue where a person is being detained or held by the government, this incentivizes the government to hold people in places and in judicial circuits where precedent will be more favorable to them, where they are more likely to get a favorable outcome in invoking the Alien Enemies Act in these cases. And finally, just to be clear, the Supreme Court here has offered no specificity on the form of notice or what constitutes reasonable time, which makes violating this requirement of due process ripe for abuse, particularly for an administration that has been bold and willing to sidestep even basic requirements of due process. And the final point I'll make, just for folks' awareness, is that really in the hours since the Supreme Court decision, the ACLU has filed 2 class habeas lawsuits right away. So these are habeas cases as the Supreme Court has requested, but that names several people at once in an effort to continue this challenge against the invocation of the Alien Enemies Act. And finally, in the meantime, we wait to all understand what, if any, is the remedy for the people who are already in El Salvador. That is something that the Supreme Court, as Dara mentioned, did not speak to. So with that, I'll pass it back to Dara.
Thank you so much, Nina. So, what we have, one of the things that you've mentioned, of course, is that when there is a normal immigration proceeding, there is, while not the amount of due process we would normally associate with, basic rights, still some sort of process. And that's exactly what happened to the client to Simon's client. And Simon, we're about to turn to you. Obviously, Mr. Kilmar Abrego Garcia did have a hearing before an immigration judge. And the result of that was that it was found that he would more likely than not be persecuted if sent to El Salvador in particular. And yet, that's exactly what happened. And we're now waiting on tenterhooks to hear if there's any way that the government can be forced to fix what they themselves acknowledge as a mistake. Simon, can you talk to us some more about your client's case and about what concerns you have about what process he was and wasn't afforded and might be afforded under the law?
Yeah, thank you very much. listening to Nana's presentation really makes me realize that, I and many of us have spent our entire careers trying to get the immigration court's standard of due process up to the standard of quote unquote real court. And now we're in a situation where we're fighting to have our clients just get the immigration court level of due process. So it really is a big step backwards. I'm sorry to say. Um, so Kilmar Abrego Garcia was first arrested by ICE in 2019 when he was working as a day laborer in front of a Home Depot in Maryland. At that time, there was basically an anonymous tip against him from a confidential informant. As Dara mentioned, it's the kind of thing that would never ever stand up in quote unquote real court. And when most people, certainly not everyone, but most people who are initially arrested by ICE as a first encounter in the interior of the United States, not like while crossing the border, but been here for a little while, get arrested by ICE, are entitled to a bond hearing relatively promptly in their detention. There's another difference. In real courts, you get a bond hearing really within 24 or 48 hours. In immigration court, it can be sometimes as long as a month. But he had a bond hearing, and at that initial bond hearing, the immigration judge sort of said, well, look, there are these allegations against him that he's a member of MS-13. They're anonymous. It's a confidential informant. I don't know what's right and what's wrong. I don't know what's true and what's false. So I don't find that he's met his burden to prove that he's not a danger to the community. Yet another difference from real court in which the government would have the burden of showing that someone needs to be detained, right? In immigration court, he had the burden to show that he can be released. So the judge says, I'm not gonna grant him release on bond pending his proceedings. But then he went on to have a trial, right? In his case, he had to do that trial from behind the bars of an ICE detention center, but he went on to have a trial and he won his trial. He applied for asylum. He was not granted asylum for the sole reason that you have to apply for asylum within 1 year of arriving in the United States, and he did not do that. So he, instead of being granted asylum, which puts you on a path towards green card and ultimately U.S. citizenship, he was granted what's called withholding of removal, which essentially it's a higher standard for him to meet, right? So he actually had to prove more than he would have had to prove to win asylum. And what it means is that he can't be deported to El Salvador, period, full stop. Now, um, the government did not appeal that ruling. They just essentially said, okay, this was the prior Trump administration. They released him from detention. He was entitled to a work permit, so he's been working legally in the country for the past 5+ years. Fast forward to early March. He's driving his kid home from daycare, and ICE officers pulled him over in a targeted operation, right? This isn't like he got pulled over by local police and then they turned him over to ICE. ICE officers pulled him over in a targeted operation. They arrested him. They said incorrectly, falsely, your legal status has changed. This was not true. And then they bounced him around to various detention centers across the southern, half of the United States for a weekend, which is another pretty typical thing, right? In quote unquote real court, when you're arrested, you're detained in the jurisdiction. In ICE, you're very often bounced around to anywhere in the country, and they do it over and over and over again. He was talking to his wife that whole weekend. You're able to make phone calls from the inside of ICE detention center. Sometimes it can take a little while to get access to a phone, but you are able to make phone calls. And then all of a sudden he stopped calling, and no one knew what happened until a friend of his wife spotted a picture of him on the news coverage of the Venezuelan Alien Enemies Act deportees who'd been removed to El Salvador to the CCOT prison, essentially on the same weekend at the same time as him. So there's really no connection between his case and the Alien Enemies Act case other than the fact that they were removed the same weekend. But from a legal point of view, they've got really nothing in common. I mean, this is a terrible case, but it's also not entirely uncommon. I've handled wrongful deportations before. Most immigration attorneys have been around for a while. It happens from time to time. In every prior case of this nature that I've handled, sometimes it takes a little bit to get someone's attention to the case. Sometimes it takes a little bit to convince them that it was a wrongful deportation. But as soon as you convince them of that, they immediately turn around and say, all right, we're gonna fix this. We're gonna bring him back. Don't worry about it. I expected this case would go the same way. I, did not expect that we would end up at the Supreme Court. I think it's preposterous that we've ended up at the Supreme Court. This is one guy from Maryland, a sheet metal worker. It need not have been a case of national importance. It's the government that decided to do that, not us. So they have leaving aside the rhetoric, leaving aside the tweets, leaving aside the White House press secretary, the defense in the case is twofold. One, they're making like an impossibility defense. It would be impossible for us to bring him back because he's inside some other country's prison now. And then two, no court, we don't have an obligation to bring him back, and no court can force us to bring him back. Because, when it comes to matters of foreign relations, we get to do whatever the heck we want. No one can tell us otherwise. Those are the legal arguments here. As to the former, they submitted no evidence of impossibility, right? And I don't think anyone in this country believes it as a matter of fact. I don't think anyone in the United States, I think everyone in the United States understands that if we actually just picked up the phone and called over to El Salvador and made a good faith ask, not with a wink and a nod, but a good faith ask, that he'd be on a plane in 48 hours, right? I think everyone recognizes that. We put in evidence, granted, circumstantial evidence, hearsay evidence, because it's in the form of newspaper articles, but those things are admissible on the posture of an emergency PRO, an emergency preliminary injunction. We put in evidence of that there is an agreement vis-a-vis this detention center, that we're paying $6 million to the government of El Salvador for an agreement that $6 million covers 1 year. Bukele tweeted this and Marco Rubio responded, "Thank you, Mr. President." Right. So we put all that evidence into the file. They didn't put any contrary evidence. So that's why we think that the impossibility defense just won't hold up as a matter of fact. But the much more troubling one is the legal defense with regards to essentially saying no court, not even the Supreme Court, can order us to do anything about this situation. Right. I mean, if that prevails, it is fairly nightmarish, because what it means is that as long as they act quickly enough, once they get someone out of the country, it's game over, right? There's no more courts. And so, essentially that sort of raises the question, well, why do we even have courts in the first place, right? Why bother having immigration laws? Might as well just not have them. Why bother having immigration judges? Why bother having immigration courts if they can conceitedly violate the orders of those courts? And as long as they do it quickly enough, it's a fait accompli and nothing can be done about that. If this is a situation in which he had an order preventing his deportation to El Salvador, if his wife had called me during that weekend when he was still in ICE custody in the United States, I would have said to her, well, don't worry. The one thing they can't do is deport him to El Salvador, right? We certainly have to worry that they might deport him to Panama. We have to figure out how we can prevent that. We have to worry that they might deport him to Costa Rica, but we don't have to worry that they're going to deport him to El Salvador right now. So I don't know. I'm happy to answer any questions, but basically at this point, we filed a preliminary injunction in the District of Maryland. The district court agreed with us. She started the hearing by saying, look, I'm only going to decide this case based on the facts in evidence, right? And so that's why she kept asking the government attorney, well, what is the evidence that supports this? What is the evidence that supports that? And he very candidly responded, well, Judge, there is none. So she issued her decision. They appealed it to the Fourth Circuit Court of Appeals in Richmond. All 3 judges agreed that the government's legal position is horrific. So that's now 4 judges who've agreed with us, not including the original immigration judge. I guess that's 5 if you include the original immigration judge. And then they appealed to the United States Supreme Court. Justice Roberts issued a temporary administrative stay. The original deadline that the district judge put was 11:59 p.m. Monday night. By the time Justice Roberts really got this case, it was like mid-afternoon on Monday, 5-hour flight. Obviously we would have rather that, he not do this, but we're not concerned about the fact that he put in an administrative stay. That really is just so that the Supreme Court can have time to, do the work that they need to do. We anticipate a ruling, hopefully this week, it could be today or tomorrow. And I mean, obviously I'm confident that we're going to prevail in this case, but we anticipate that the Supreme Court is going to move quite quickly on this.
Thank you so much, Simon. And thanks to folks who are asking questions about Mr. Abrego Garcia's case. You know, we we defer to Simon as to whether or not it would be, safe and prudent to answer those. But we do actually have a breaking news update in another aspect of this. And so, Erin, before getting to your kind of scheduled presentation, can you explain to us what the ruling that just came down since we started this webinar is?
Yes, so I have some honestly breaking news. About a few minutes ago, a federal judge in Texas, in a case filed by the ACLU Texas on behalf of 3 of the named plaintiffs in the ACLU, in the lawsuit on the Alien Enemies Act, they brought a habeas challenge, a class action habeas corpus lawsuit against the Alien Enemies Act. A federal judge in Texas has just issued a restraining order saying that that the federal government may not transfer any person outside of the El Valle Detention Center, which is where the people were held for the March 15th operation. So those people cannot be taken out of that facility, including the named plaintiffs. This means that if they are going to use the Alien Enemies Act for any individuals, they won't be able to use the same facility they used before. And so that is in the first court order post the Supreme Court blocking the use of the Alien Enemies Act for any individuals. They were seeking a broader class action, but as a temporary measure, the court has said no transfers out of the area. You can't do that. So we've already seen post-Supreme Court judges step in and say, you need to wait. You cannot rush people on a plane, really reinforcing what the Supreme Court said about the need for due process here. I will note there is a second lawsuit pending in New York with 2 other of the plaintiffs that from the original ACLU lawsuit. There is a hearing that I believe is either going on right now or has ended just a little while ago. We also expect a decision in that case, but on a temporary restraining order request quite soon.
Thank you. So thinking back to, there's one moment that really stuck out to me in kind of Simon's story, where he was talking about how before the deportation, he would have been concerned that Mr. Abrego Garcia was going to be sent to Panama or to Costa Rica, just not to El Salvador. And of course, conversely, the Venezuelan men who were sent to El Salvador had no idea. We've heard some stories that some of them thought they were going back to Venezuela and found themselves in El Salvador instead. How did we get to a point where people are getting removed to countries that aren't the country that they originally came from and that they have no connection to? Can you talk us through what these third country removals are and what due process is available to people in these cases?
Yeah, so third country removals are not unheard of in immigration law. And Congress, when it sort of crafted the law around where people can be removed to, envisioned that there would be some people who would be deported to a country that they didn't come from. And there's a pretty complicated set of rules around how that's going, with, of course, the default rule being you get deported to where you're from. If you're Mexican, you get deported to Mexico. If you're Salvadoran, you get deported to El Salvador, and so on and so forth. But this issue of third country removals and the inability to deport some people to specific countries is not a new one. Since the 1960s, for example, for about 50 years, Cuba prevented the people from being deported from the United States to Cuba. And so when Congress drafted these rules, they understood it wouldn't always be possible to carry out a deportation, and provided that the United States government could reach an agreement with a third country to accept nationals that were not their own. However, some individuals, but this use of third country removals was until relatively recently quite rare. So Simon mentioned withholding of removal and the rules around that. This basic principle, you can be deported, but there's one country you can't be deported to, and that's the country we granted withholding of removal to. The American Immigration Council and another organization did a Freedom of Information Act request on withholding of removal data to say, how often do these third country removals occur? And our this was data from 2017, so it is out of date, but it was pretty typical of what things looked like in the 2010s at least. Found in 2017, 1,274 people were granted withholding of removal. 21 people were deported to a third country. So that was 1.6% of people granted withholding. So that meant that once you were granted withholding of removal, the overwhelming likelihood was that you would get to stay. Third country removals were extremely rare and they occurred on an ad hoc basis only. That said, this began shifting in the last decade, and most notably under the Trump administration, with the Remain in Mexico program. Now, Remain in Mexico was not deportations, but it started this practice of externalizing people to other countries. And under that program, you had tens of thousands of people being forced to wait in Mexico who were not Mexican. And then in 2019, late 2019, the Trump administration signed so-called safe third country agreements. Agreements where they would take people who were detained in the United States or who were migrants who are encountered at the border and deport them elsewhere. The only agreement that ever went into effect was the agreement with Guatemala. And under that agreement, we sent about 1,000 Salvadoran and Honduran migrants to Guatemala and deported them there. Formal, full deportations under US immigration law. That agreement was suspended when COVID hit and then taken back when the Biden administration took office. But then Biden himself presided over the most significant increase in third country deportations in US history. And that was an agreement reached with the Mexican government in 2022 to deport Venezuelans under Title 42, expel Venezuelans under Title 42 to Mexico. This was then later expanded to Cubans, Haitians, and Nicaraguans as well in January 2023. So we have seen under the Biden administration tens of thousands, if not hundreds of thousands of non-Mexican nationals sent to Mexico, either first under Title 42 and then after Title 42 ended under normal immigration law. Tens of thousands of Venezuelans and others were formally deported to Mexico after being encountered at the border. But the key distinction there is that those individuals were not people arrested in the interior. They were migrants. Same with the safe third country agreements. So what we have seen now with the Trump administration, the second Trump administration, beginning to use third country removals for people who are not necessarily encountered at the border is a new aspect of it. Now, how does this relate to how does this relate to the Alien Enemies Act? Well, the Alien Enemies Act is its own thing. There's no actual provisions in the Alien Enemies Act about where people are to be deported to. So here, the Trump administration has really, I hate to use the word, innovated in the use of this law, in that they're just invoking it in a way that it's never been used before and in a process that's never been used before. In previous years, when the Alien Enemies Act was used, people could leave on their own. Of course, there was an ongoing war, so we were not in World War II deporting Germans to Germany. But people would have to leave the country and find their own place to go to, or they were detained throughout the course of the war. So to some extent, those weren't third country removals because we were not deporting people to third countries, but people were expected to just leave the United States on their own power. This is the first time that the United States has used the Alien Enemies Act as a tool of deportation, and certainly never sending people to third countries. And crucially, one thing to really emphasize here about third country removals is that they don't allow you to sell someone to a country to be imprisoned there. The whole deal is you reach a deal in which somebody is deported to that country, not necessarily imprisoned to that country. And in the past, there have also been opportunities under US law for people to raise objections. Of course, with withholding of removal, if the government wants to get rid of it or send somebody to a third country, they are required to give notice. They're required to give people an opportunity to raise separate claims. And there is a lawsuit out of Boston right now called the DVD litigation, under which a judge has already ruled that the Trump administration's decision to start deporting people to third countries, even under normal immigration law, not even the Alien Enemies Act, without telling them where they are going and giving them a time to raise an objection is unlawful. So there's a temporary restraining order in that case, because as Simon said, when people were picked up, there was a worry maybe they'd send him to Panama, maybe they would send him to Costa Rica. But at the very least, if that had happened, they were required to give him a notice that they were going to do that. But the Trump administration wasn't even doing that under normal immigration law. And so a federal judge is also blocking that policy. So we are seeing this administration really expand the use of third country removals before, but it has required, and they are doing so without process. And that's like the key distinction here. They want to execute removal orders and get away from process. Anything that slows them down, that prevents them from carrying out deportations is something they're trying to get around. And as we're seeing literally moments ago and in the last few days with this DVD litigation, these third country removals are being stopped in court, or at the very least, judges are demanding that people get due process, that no one be sent to a third country with no warning. Because of course, just saying you're okay, we're not going to deport your home country doesn't mean you're going to be deported somewhere safe. US law obligates the United States not to deport people to places where they will be persecuted or tortured. And some people will be persecuted or tortured in those third countries. I think one could certainly argue that what is happening in Venezuela, in El Salvador with the Venezuelans is likely torture. The conduct that is happening there is outrageous. And of course, one other thing that we're seeing here is this idea of chain refoulement. Refoulement is the French word for sending someone to a place where they might face persecution. And so what we're seeing is places like Panama and Costa Rica is that once somebody's sent there, that other country may then send them back to their home country. So we're seeing a situation, for example, where a Salvadoran who had withholding might be deported to Panama, and then Panama might turn around and deport that person to El Salvador. And so the United States has an obligation not to be involved in these sort of chain removals. And this is why it is so important that we just uphold the rights of due process here in these cases, and that we don't let the Trump administration simply bypass the law and get around these orders and obstacles, because that is certainly what they're trying to do.
Thank you. So when we're talking about the risk of, refoulement, the risk of persecution, the risk of torture, the stakes are obviously very high. And it seems perhaps, important that the US be thinking about what conditions they're likely to send people back to before they do. Where the Trump administration appears to have chosen to partner with the Salvadoran regime of Nayib Bukele and his SECO center. Will, can you talk to us about what the Bukele regime has done and why it's significant that this is who the Trump administration is using as their go-to partner in these removals?
Absolutely. So first, let me just say, why am I commenting on this, a foreign policy expert who doesn't usually talk about, U.S. immigration policy? It's because the Trump administration has chosen to make this a foreign policy issue, right? The moment that Trump emitted the executive order claiming that the Venezuelan gang Tren de Aragua is conducting irregular warfare in league with the Venezuelan government and undertaking hostile actions inside the U.S., this became a foreign policy issue, and I think brought people like me into this conversation. By the way, just on those claims that are the basis of invoking the Alien Enemies Act, the CIA and NSA, according to the New York Times reporting, dispute that Tren de Aragua is involved in this kind of hostile action in the U.S. And has those solid links and direction from the Venezuelan government. The FBI was the only major intelligence agency to actually dissent with that statement. So the entire invoking of the Alien Enemies Act, very questionable, but it makes this immediately a foreign policy issue. So yeah, let me provide some background on El Salvador, the type of conditions there, and why the Trump administration has chosen this partner, and for that matter, why Nayib Bukele is going along with this plan. So very briefly, Nayib Bukele was elected president in El Salvador in 2019. Framing himself as an anti-establishment candidate, won by quite a large margin against some really discredited traditional political parties. And at that point, homicides in El Salvador, which had peaked around 2015-16, they were already steeply declining. But by global standards, El Salvador was still a very violent country with powerful gangs. So in March 2022, after almost 100 murders in a single week, Nayib Bukele led his party in the legislature, which had gained a commanding majority, to authorize an emergency declaration to combat gang violence, placing the country and its prisons under a legal state of the exception, which ever since has suspended constitutional rights for both nationals and foreigners accused of ties to El Salvador's largest gangs. These rights, of course, include being informed for the reason of arrest. That is not a right Salvadorans have had since March 2022. Appearing before a judge within 72 hours. Similarly, that right was dismantled in El Salvador. And what you saw afterwards, in the almost 3 years since, was the jailing of 85,000 people. El Salvador now has the highest incarceration rate in the world, with almost 2% of the adult population in prison. Which brings us to the Secot, which was built at the outset of this state of the exception and the crackdown that we've seen in El Salvador. So the Secot, the terrorist confinement center, was built as a sort of maximum security prison, which the Bukele regime would like the world to think is the model prison and where every alleged gang member is going in El Salvador. In fact, if you can believe it, the Secot is the PR stunt prison. That is the prison that shows up in social media posts that makes the government look tough and imposing, and like it's kind of has this innovative approach to gangs. In reality, many of the 85,000 who've been jailed have been crammed into pre-existing, much more overcrowded, much more dangerous prisons in which we actually have more firsthand reports of torture, of abuse, of beatings, of rape, of other type of abuse from state officials. That said, the Secot is subject to all that same lawlessness of the prison system in El Salvador as a whole. Inmates there have no access to lawyers, they have no access to family. International observers have gained very sparing access. I mean, it's really only influencers invited by the government of El Salvador and other foreign media figures who are given short guided tours and then taken out. And I think it's important to underscore, just writ large in the prison system in El Salvador, since the state of exception in March 2022, one person has died every 3 or 4 days inside the prison, according to the human rights organization Cristosal. Those are the deaths we know about. And of course, that's probably just a fraction of the overall total. I'll say that, looking ahead, there are no trial dates set for almost any of the 85,000 people detained without warrants in El Salvador. And the government has said that when it does start trials, it'll be trying people in batches of 900 in virtual sessions with secret judges who can hide their identity. So that's just to say that since 2022, there's been no law, no due process in El Salvador. Anyone can be whisked off the street if they're accused of gang ties. So why is Bukele collaborating with the US government? I think that's an important part of this question to look at. After Secretary of State Marco Rubio visited, Bukele said he would be happy to open his prisons to anyone that the US would like to send there, even US citizens. Rubio called it an unprecedented gesture of collaboration that no country had ever given to the US before. But there must be something in this for Bukele, right? And besides the $6 million, I think there is. So there are strong pieces of evidence that suggest that Bukele, prior to his gang crackdown in 2022, was engaged in ongoing negotiations with El Salvador's largest gangs in an attempt to control violence, which is something that governments before him had done. But let me just quickly run through this evidence so you can see how commanding it is. So first, Central American media outlet El Faro published photographic and documentary evidence that top Salvadoran state officials under Bukele, including the prisons director, were meeting secretly with gang leaders in jail, giving them favors, giving them money in return for political support and promises to lower violence. After that, you saw the Attorney General in El Salvador begin wiretaps and surveillance to investigate these officials. He was eventually illegally purged by Bukele, but not before producing corroborating evidence. And then finally, between July 21st and February 22nd, the Bukele government actually released 4 leading gang members secretly from prison in El Salvador, who were expected to be extradited to the US. They were allowed to flee into, or they're actually transported into foreign countries and allowed to live at large. The icing on the cake is that the US Treasury Department and district prosecutors in New York both backed up these accusations when they began prosecuting Salvadoran gang leaders in the US when they ended up in US custody. So you have this battery of evidence that Bukele was negotiating. So why is he cooperating with Trump now? Why is he bending over backwards to work with the Trump administration in this really unprecedented way? I think it's pretty clear. It's because he wants the gang leaders who are now outside El Salvador, including those in US custody, back in the country. In fact, his ambassador to the US said in the past couple of weeks, the one thing we want is our gang leaders back, making it very clear. And so, I think that the clear plot here by Bukele is to get these people back, make sure that they cannot speak, they can never reveal the truth of how he really pacified El Salvador. Why then is the US government collaborating with this regime? I think one, it's because of Bukele's immense popularity regionally and worldwide. Organized crime is a very real problem in Latin America, needless to say. People are desperate for solutions. Democracies haven't always provided them. And Bukele has become extremely popular by selling the idea that only his model, right, only dismantling rights and installing a police state is the only way to free people from the power of organized crime. I think although the conditions are wildly different in the US and much safer, the Trump administration wants to ride the coattails of that message. as you saw when Kristi Noem visited the Secot as well, posing in front of, I'll add, Salvadoran inmates, not Venezuelans, she said this is a tool in our toolkit for deterring migration. So I think that's another aspect of what's motivating this this cooperation. But writ large, I'd say, and maybe this is controversial, but I think El Salvador has become the Cuba of the right. That's to say, for decades, leftists around the world flocked to Cuba, praising it, ignoring the political prisoners, ignoring the killings, ignoring the gross injustices, and claiming that it was okay that there was no democracy there because there was a measure of social justice. And the same thing's happening right now with El Salvador and the global right, especially in the US. They're saying it's okay there's no democracy there because they've achieved safety, and saying that maybe there's even something to emulate in that model. I'll just wrap up because I know we're short on time here by saying that I do think there's, we should be watching for ways that these practices could expand and actually get worse. So one way in which it could expand is, of course, we've seen mentions from members of the Trump administration, including White House Press Secretary Carolyn Leavitt, that Trump has discussed privately and publicly the deportation of U.S. citizens, right, which would face huge legal hurdles, obviously, if Fifth Amendment challenges. But Bukele has offered it, and I think we should be on guard that he's very desperate, right, again, for this cooperation of the U.S. And to satisfy Trump. And then secondly, and I'm glad Panama's already come up, I just came back from there, but I would say that we should watch for ways other Central American countries can be roped into this. There's immense leverage when it comes to the US and small Central American countries. I mean, completely different than Mexico or South America. These are countries which have a lot to lose and which the US can punish immediately and very consequentially for any kind of resistance to this agenda. So, in Panama, we're talking about credible threats to take back the Panama Canal, which is 5%, and if you include the economy around it, 20% of Panama's GDP. That's what has the government, walking on a tightrope there. And so I think they're under a lot of pressure to cooperate with the Trump administration in any way they're told on migration. In Guatemala, you have a government that narrowly survived a coup effort to actually make it into power. They also, there's huge sources of leverage of the U.S. over Guatemala's government. Costa Rica and Honduras, for more cynical reasons, I think their governments are interested in aligning with the Trump administration. And helping implement these policies. So it's not just El Salvador, even if really that's the worst offender. And I think that's where we're seeing the worst practices so far. And then finally, without U.S. intervention, what outlook can we expect for those housed in Secot? And I think simply it would be the same outcome as the Salvadorans housed there, which is that they'll never be released, and we will lose public record of them. We'll lose the ability to track them, to know their whereabouts, their condition, and they'll end up in the same situation of opacity that so many Salvadorans are subject to in that same prison. Thank you.
Thank you so much. Folks, I understand that we are going to be a little bit short on Q&A. We are going to go a little bit past 1 in order to address at least some of your questions. Obviously, if you have to jump off, then I apologize, but we're going to go absolutely no later than 1:10 and hopefully more like 1:05. So first of all, in terms of questions, Simon, can you explain to us exactly what it is that we're expecting the Supreme Court to rule on?
Yeah, so the district judge in Maryland put a deadline by which the government has to facilitate the return, that's the exact quote, of Mr. Abrego Garcia to the United States. That deadline was 11:59 p.m. this past Monday. The Supreme Court sort of put a temporary pause on that deadline just so that they could figure it out. What the government is asking is for that particular order of the judge to just be stayed pending the entire litigation, right? So in other words, we'd have to go back to the district court, do months and months of discovery, depositions, blah, 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 before the judge could issue a final ruling in the case, which then presumably they would appeal all over again. What we are asking the Supreme Court is to not do that and to allow the judge's order to take effect. Obviously, the Supreme Court will have to put a new deadline because the original deadline has passed. But other than that, just let it take effect. And one never knows when they will rule, but I expect it to come quite promptly.
Thank you so much. So Nina, can you talk to us some about, obviously the Supreme Court tried to require some sort of reasonable notice, but what does that actually mean in practice? What are the limitations associated with the use of habeas claims to try to get some kind of, due process for people who are challenging removal?
Yeah, I mean, I think it's worth just saying up front, we are in a bit of uncharted territory here, right? So just to reiterate what I said, the court has not offered any details on what would suffice as reasonable time to give somebody notice. And it has also, left open questions on what the form of notice would look like. And so I think we'll have to see how the government acts. And then, if necessary, there'll be litigation, specifically on this question of whether the notice and time the government's offering folks is sufficient. Now, I mentioned in my remarks, I'm happy to repeat a little bit here that habeas petitions, they don't happen overnight. In my experience, federal district judges, unless under the pressure of a request for a temporary restraining order, usually give the government 60 days to respond to the filing of a habeas petition. That then has to be litigated. Sometimes there are arguments in court. The judge considers a decision. That means the litigation could go on for weeks. Will the Trump administration give people sufficient notice to both file and fully litigate a habeas? Will federal judges be willing to stay removals, to order the government, like we've seen here now in Texas, preventing them from removing people while a habeas case is litigated? Those are questions that we'll have to, see how those play out. But habeas, is a very important tool to help people who are subject to deprivations of liberty. But it doesn't happen overnight. And it does usually require a lawyer to be effectively argued. And all of that will contribute to delays of time while people remain detained under certain conditions. Or rather, sorry, under inhumane conditions.
Thank you. Erin, can you explain why are people shuttled between ICE facilities so often?
Yeah, so some of this is just the nature of ICE detention. ICE has dozens of detention centers around the country. They have contracts with some detention centers that require them to maintain minimum populations. And right now, they have a shortage of detention beds. So people get moved from place to place sometimes for reasons just to do with satisfying contractual minimums. And sometimes it's also about what their access is to infrastructure. The majority of detention centers are in the South, and the only detention centers which are used for staging deportation flights are also really in the South, in Arizona, in Texas, and in Louisiana. And so people get moved around for these various reasons, not just because the government wants to take everybody to the Fifth Circuit where the case law is worse, but sometimes it's just because they have an empty bed there and they need to get someone there. Of course, there have been allegations in many specific cases that people are moved some places to get them away from their lawyers. And while I'm not making any allegations in these specific cases, sometimes, in this case, we know, for example, that the flights to El Salvador were all leaving from one place, the El Valle Detention Center. And so they had to bring people from all around the country down to that detention center to carry out these deportations because they had to get them all on a set of planes. So it's a little bit, yeah, go ahead,
Aaron,
Simon.
I just want to say they may not be bringing a particular human being to a detention center in Texas because they want that human being's case decided under Fifth Circuit law, but they sure as heck built that detention center in Texas because they want everyone's case decided under Fifth Circuit law.
Yeah, and also it's not just that, it's also the states that are most friendly to the private prison industry are southern states. And the states that are least friendly are oftentimes northern states. And so this is a part of it as well. State laws and state policies play a role of where are the jails being built, where are they being maintained, and where are these companies operating. So it is a whole combination of those factors goes into that, but the end result is people get shuttled randomly around the country, sometimes for no apparent reason, and often end up in the Deep South.
Thank you so much. So obviously SICOT has these Salvadorans who have been detained under the state of exception, and it also has these Venezuelans who have been sent by the Trump administration. how is that even working? Do we know anything about where in Sicot people are being detained?
Yeah, so the Salvadoran government claims that the Venezuelans, subject to this rendition, are being held separately from the general inmate population, but there's nothing to verify that. And I think that speaks to just the opacity of this prison and the prison system generally in El Salvador, that access is so limited that we don't even know, we can't know, right, where they're being held. And I'll make one more comment there, which is, you saw when Kristi Noem went, and this is the standard sort of influencer tour circuit through the prisons, is that they pose in front of the cells, right? And the inmates held within are heavily tattooed Salvadoran men. But it's just worth pointing out that, as Noah Bullock of Cristo Salas pointed out in his writing, those inmates are middle-aged gang members who were detained before Bukele's state of the exception. That is the image that Bukele wants you to have of the inmate population in El Salvador. I think it's the image the Trump administration wants us to have of the men sent there, or wants the general public to have in the US of the men just sent there. That is not representative of kind of what most inmates in the system look like, right? Many of these people scooped up off the streets of El Salvador are being held in prisons where we never see them, right? And people with flimsy, if any, basis to their alleged gang ties, who I think would, if shown to the world, would give a very different picture of the prisons there. So I don't expect that we're going to see images either at any point. That would in a way cut completely against the PR stunt purpose of the Sicot prison, both for Bukele and for the Trump administration.
Thank you. I know we have a bunch more questions, some of which, we have speakers diligently typing out answers to before we have to finish. But unfortunately, in order not to take any more of your time than we've already stolen from you, we do have to wrap up for now. If you have further questions, you can reach us there will be an email to reply to in the email that you get. After this, you can reach out to any of us at the council individually, we have contact information on our web pages. Thank you so much for remaining engaged with this. Whether or not, like, if you're at all interested in what's been happening here, obviously this is something that is continuing to unfold. And so the best thing we can ask you for is to just remain engaged and to make it clear to others that this is something they should be paying attention to. Our colleagues at Immigrant Defenders, who represent Andres, among others who were sent to El Salvador, have been saying that they found it helpful for people to call their members of Congress and ask for the return of those who were sent to El Salvador. We know that there's been some very powerful reporting out there, and that not everyone has seen, not everyone watches 60 Minutes, not everyone reads Mother Jones. Some of these stories of the people who are caught up may not have come to the attention of people who would really want to know what the US is doing in their name. So as long as you can remain engaged, keep sharing resources, keep yourselves informed, we can make sure that the people who, arguably the US or El Salvador are trying to disappear don't in fact fade from public view. Thank you very, very much, and have a good afternoon.